Hello, everyone, and welcome to Lesson 8, the Judicial Branch, the Federal Courts. The judicial branch of government was new to the United States of America under the United States Constitution. Under the Articles of Confederation, states had separate courts, and there was just a loose oversight from the Congress of the Confederation. But Article 3 of the Constitution sets up the Supreme Court, while the other courts in the land, the district courts and the appeals courts, are set up by the Judiciary Act of 1789. There are three levels of courts that are supposed to enforce national laws and hear appeals. The first is the Federal District Court, the second is the Federal Appeals Court, and then the third of these is the United States Supreme Court. Now, the major power of the judicial branch is something that we call judicial review. And judicial review will come out of the court case Marbury versus Madison of 1803. And what Marbury versus Madison states is that the Supreme Court, and in theory all the federal courts, have the power to declare congressional and/or presidential acts invalid because they violate the United States Constitution. And the person that made this ruling is Chief Justice John Marshall. And John Marshall will be one of the more important Chief Justice of the United States Supreme Court, and he'll be Chief Justice from 1801 to 1835. Now, this is a power that is not specifically stated within the Constitution. It's implied, but this is a power that nonetheless Chief Justice Marshall outlines for his court and for all future courts. Now, the United States District Court. There are currently 94 district courts, and these courts deal with federal criminal cases. They also deal with civil cases that claim some kind of violation of federal law. They also deal with civil cases that are brought against the United States government, and also civil cases where a resident of one state, say the state of Texas, sues a resident of another state, say the state of Louisiana, over a sum of $75,000 or more. This is also the lower level of the federal court system. This is the district courts. The second level of the court system in the federal courts is the United States Court of Appeals. There are currently 12 U.S. Court of Appeals, and these will actually handle appeals of decisions by the United States District Courts. And one thing that they do is they follow what we call precedent. Now, precedent is defined as a judicial ruling that serves as a basis for later rulings. Meaning, if something is ruled on once or twice, essentially that becomes the understanding of the law until a law or a constitutional amendment is passed that changes it. So precedent is something that's very important within our federal and state courts. Another thing that they have the power to do is what we call stare decisis. And this means let the decision stand. This means that if a case is heard by the federal court, the district courts, they can then demand that the decision stand as final. This is the U.S. Court of Appeals. The United States Supreme Court. This is designed to be the highest judicial authority and the final interpreter of law. Each member of the Supreme Court is appointed by the President of the United States and must be confirmed by the United States Senate. Currently, we have a makeup of the court of 9 justices, the Chief Justice of the United States Supreme Court, and 8 associate justices. These justices serve for life. This is a lifetime appointment. That's why it's very important who is appointed to the Supreme Court. And the pay for the Chief Justice is about $260,000. The associate justices make about $249,000 to $250,000. Now, the Chief Justice is a peer. He is an equal member to the other associate justices. The only thing that he has above them is he is the administrative head of the court. He is the one that kind of steers the court. But in theory, they are all technically equal under the law. Now, what are the powers of the United States Supreme Court? Well, first of all, the Supreme Court has what we call original jurisdiction. This means that under Article 3, Section 2, they have the authority to hear any case before any other court. They are essentially the most powerful court in the United States. They are also the appellate or court of last resort, meaning that they have the final say, whether it's an appeal or a ruling. You can't go and ask anybody else to overturn their decision. Also, they deal with all federal questions, whether it's the U.S. Constitution or national laws or U.S. treaties. Now, in order for them to take a case, they have something that's called the Rule of 4. Even though there's 9 members of the court, it only takes 4 members to agree to take a case. So as long as 4 members are on board to hear a case, the whole Supreme Court would then hear whatever the case is, whether it's an abortion case or a gun rights case. It only takes 4 for that case to be heard. Now, there's 2 philosophies when it comes to Supreme Court justices or lower court justices or judges. And this is the idea of judicial restraint versus judicial activism. Now, what is judicial restraint? Well, this is when judges defer to decisions of the elected branches, meaning they judge the laws written by Congress and the actions of the president based on the law and based on the idea that they are elected by the people. Judicial activism is different. This is a philosophy that judges do not defer to the decision of the elected branches. They interpret the law as it is understood by the Constitution. An example of this would be, let me give this example, would be the Second Amendment. The wording of the Second Amendment states that in order to create a well-regulated militia, that people are allowed to own firearms. Well, in the 1990s, early 2000s, there was a case where the Supreme Court actually ruled that no, the Second Amendment gives everyone the right to own a gun for personal protection. Now, while you could make that argument, the wording of the Second Amendment is clear that in order to create a well-regulated militia, and so essentially the conservatives on the court acted on their own personal belief of the Second Amendment being there to protect, a person's personal property and themselves versus the whole militia part of the Second Amendment. I'm not saying that's been wrongly decided, but that would be the difference between judicial restraint versus judicial activism. And while both sides say they don't want judicial activism, both sides engage in it. The liberals on the court are most definitely involved in judicial activism, and the conservatives who are always preaching judicial restraint and following the Constitution as is, they also conduct judicial activism all the time. So this is not something that's new. Now, when you read a Supreme Court ruling, there are 4 things you have to look for. The first is what we call a judgment. Now, a judgment is the decision. This is the decision of the case. And this is usually written by the Chief Justice or the person, if the Chief Justice is in the minority, the person who the majority chooses to write that opinion. So this is the actual outcome of the case. Now, within that, there is what we call the arguments. And this is the majority decision. You could have one argument You only have one argument. And this is essentially why the judgment is what it is. Now, we also have something called a concurrence. This is when they agree with the argument, but they agree for a different reason. Maybe the argument says we state that this judgment is correct because of Article 2, Section 5 of the Supreme Court, whereas the concurrence will say we agree with the argument, but we don't believe that Article 2, Section 3 applies. Instead, we believe it's more likely to be the 14th Amendment to the Constitution would be why we agree with the argument. Realistically, it doesn't matter. They're all in agreement that the judgment is correct. They're just making different cases. Now, the final thing that you'll see in a Supreme Court decision is what we call the dissent. This is done by the minority. Sometimes there's one dissent. Sometimes every person does a dissent. And this will outline their legal reasons for why they disagree with the judgment. Sometimes you'll see two people dissent, and maybe there is a concurrence with a dissent. So, for example, maybe Chief Justice John Roberts will write one dissent, Justice Samuel Alito will write a second dissent, and Clarence Thomas will concur with Alito's dissent. But maybe disagree on some part of it and have to give his particular ruling on that. So when you look at Supreme Court decisions, just keep in mind the differences between the argument, a concurrence, and a dissent. Now let's look at how you become a Supreme Court justice. Well, in order to become a Supreme Court justice, first there must be a vacancy. So either there has to be a death or resignation of a member of the Supreme Court. We're currently seeing this at this time with the death of Ruth Bader Ginsburg, the Associate Justice of the Supreme Court, that happened in mid-September of 2020. So what happens is when a vacancy is open, the President of the United States gets to make an appointment. It is then sent to the Senate. And then under what's called a Senate courtesy, both members of the home state are supposed to agree to this appointment. And they will have with them what's called a blue slip. If they return their blue slip, it is all right. If they decline to return the blue slip, the appointment is dead. Now, that is the tradition, but recently Senate Majority Leader Mitch McConnell has gotten away from honoring blue slips and has kind of changed the Senate ruling on this, but this is still technically the procedure. If the Senate members from the home state agree, then this goes to the Senate Judiciary Committee, where there will be a set of hearings where they will talk to the appointment. They will also talk to witnesses for the appointment and hear testimony why this person should be on the Supreme Court or why this person should not be on the Supreme Court. It is then up to the Senate Judiciary Committee to make a recommendation. They will either recommend that this goes before the full Senate, or they will recommend that this appointment die. At that point, if it is recommended that it go before the full U.S. Senate, there will be a vote, and it is by a simple majority. So you just need more yeses than nos in the case of the Senate because it's usually fairly highly politicized. You need about 50 or 51 votes. Now, I said 50. Currently, we have a vice president who's a Republican, so if it was a 50-50 tie, the vice president could theoretically come in and break the tie. We have never had a vice president break a tie for a Supreme Court nominee, so that would be highly unlikely that would happen, but it is technically possible. So 51 is where I like to say, but it could actually be 50. If that person is approved by the United States Senate, they are then sent to the Supreme Court where the Chief Justice, or in this case, if the Chief Justice is the one being named, an Associate Justice will swear them in. There is normally 2 swearing-in ceremonies, one at the White House, and then the official one, which is done at the United States Supreme Court building. Now, the lawyer that will go before the United States Supreme Court the most is what we call the United States Solicitor General. Now, the Solicitor General is appointed by the President of the United States, and he is the 4th highest ranking person in the Justice Department, sometimes the 3rd, depending on if there is an Associate Attorney General. Sometimes it's just Attorney General, Deputy Attorney General, and Solicitor General. Currently, he's the 4th highest ranking person in the Justice Department. And the Solicitor General will represent the incumbent government in the Supreme Court, meaning the administration. So in this case, the Solicitor General, his job is to represent the Donald J. Trump administration before the Supreme Court. The Solicitor General is assisted by 4 Deputy Solicitor Generals and 17 assistants to the Solicitor General. Now, the Solicitor General of the United States usually will hear anywhere from about 6 to 9 cases a term. The rest of those cases will be argued by his Deputy Solicitor Generals. And the Solicitor General is sometimes referred to as the 10th Justice of the Supreme Court because of how closely he works with the other 9 Supreme Court justices. He is not a Justice of the Supreme Court. That's more of an honorary title.